not hearing anything, and I think we just admitted one of them. All right. Oh, there's the chat. No for Mr. Zlotnick and Ms. Armstrong. Do you know any of the advocates you see on the screen? Advocates, are you seeing everyone you're supposed to be seeing on the screen? Before we start, make sure we got everyone. Okay. We will go ahead and get started. I am live streaming this. So we are here for the third round of this year's Summit Cup. We already did the conflicts check. Will the attorneys please enter their appearance?
Good evening, Your Honor. May we make appearances on behalf of the plaintiff?
Yes, you may.
My name is Enrico Trevisani. Today I'm representing the plaintiff, Cam Donaldson. Today I'm also joined by my co-counsel.
Okay.
Good evening, Your
Thank you. So I'm going to definitely need you to spell that for me.
Yes, Your Honor. My last name is spelled Trevisani.
I think you have it up there too. S-A-N-I. Okay. And your co-counsel is?
Good evening, Your Honor. My name is Jack Ayers. The last name is spelled E-Y-E-R-S, also appearing on behalf of the plaintiff, Cameron Donaldson.
And your team name is?
Maroon Peak, Your Honor.
Your Honor, also on screen is Cam Donaldson, Lou Donaldson's daughter, who is suing both individually and as the representative of his estate. May she introduce herself on screen?
That's fine.
Hello, my name is Cameron Donaldson.
And from the defense?
Yes, Your Honor. Good evening. My name is Ryan Chancellor, and I, along with my co-counsel,
Catherine Patton.
represent the defendant in this case, Miss Karen Baja.
And your team name is?
Quandary.
All right. Can I have all of the advocates, all the witnesses turn their video on and raise your right hand? Please indicate by saying I do if you swear to abide by the rules of this proceeding and to conduct yourself in a manner that is honorable to this forum.
I do.
I do.
So we are now officially calling the case 082263 Cam Donaldson versus Karen Bossier. We will start with any preliminary matters from the plaintiff.
Yes, Your Honor. First, we would ask for a constructive sidebar since in this virtual format, we have no way to approach the bench. We would ask that objection arguments constructively be heard outside the earshot of the jury.
That's granted.
Your Honor, we also understand that you have received an electronic notebook of all the documents and exhibits. We just wanted to confirm that that was the case.
I do have up on my screen here a complete copy of the case problem. I would ask if you're gonna, refer to something, just tell me the page number. The document page number would be the easiest, so I can kind of refer to it. Yeah, that's what I have. If there's something else that I should have, let me know.
Yes, Your Honor. That is, to our understanding, all that you'll need for today's trial. And with that, we're ready to proceed.
Okay. Any preliminary matters from the defense?
Yes, Your Honor. May we presume that witnesses are constructively sworn when called to the stand?
Yes.
And would you like us to ask permission before we start sharing screens with the witnesses?
The first time that you publish an exhibit or admit an exhibit, I would ask that you ask to publish it to the jury. But once an exhibit has been admitted and I've granted permission for it to be published to the jury, you can publish it to the jury via sharing your screen at any point that you want to. The trial, just let me know that's what you're doing.
Yes, Your Honor. And with that, that concludes the defense's preliminary matters. We do have one motion in limine.
Okay, any motions in limine from the plaintiff?
None, Your Honor.
All right. Defense, what's your motion?
Your Honor, pursuant to Federal Rule of Evidence 702 and 703, we move to limit certain opinions that we anticipate will be elicited from the plaintiff's witness, Taylor Pride. If I can make an offer of proof.
Please do.
I anticipate that this witness will be qualified as an expert in forensic document examination. Your Honor, if this witness is qualified in forensic document examination, certainly he can give an opinion about whether or not he believes the signature on Lou Donaldson's last will was forged, but he cannot give an opinion regarding who he believes forged the signature on the will and who is responsible for Lou Donaldson's death. He cannot give an opinion regarding who's responsible for Lou Donaldson's death because if this witness is tendered as an expert in forensic document examination, this opinion would be beyond the scope of his expertise. Additionally, under Federal Evidence 703, an expert may base their opinion on facts or data that the expert has been made aware of or personally observed. In this case, Mr. Pride did not conduct an investigation into who could have forged the signature on the will. He only looked at the signature of Lou Donaldson's. And as such, any conclusions regarding who forged the signature on the will and who is responsible for the death of Lou Donaldson must be excluded.
Response from the plaintiff?
Yes, Your Honor. This witness is both an investigator and a forensic document examiner. Opposing counsel is correct that they have specific expertise in forensic document examination. But as to their role as an investigator, they should still be able to testify as to what they found throughout that investigation and the evidence that they uncovered. We don't intend for this witness to offer any expert conclusions as to who killed Lou Donaldson or anything of the sort. But they should still be able to testify as to the entirety of the scope of their investigation, not just testimony relating to the document examination.
So I guess this is for the defense. Assuming that the only opinion that is rendered on the issue is that the document was in fact forged, and that the expert is allowed to testify to the facts that they uncovered during their investigation, which would lead one to believe who forged the will and who caused the death of this individual. Obviously, that is a conclusion the jury will draw. Is there any objection to the facts coming out if, I guess, the ultimate conclusion, at least on those two issues, is not stated by this expert?
No, we would be all right with that, Your Honor.
Okay. And Mr. Ayers, if I'm pronouncing that correctly, is my understanding of what you would be getting into correct? The opinion would only be that it is forged. Otherwise, he would just be giving the facts and information that he uncovered during his investigation, not the ultimate conclusion.
Yes, we don't intend to offer an ultimate conclusion as to who forged the will or who killed Lou Donaldson. We just ask that from an evidentiary standpoint, she be able to testify to the entirety of the scope of her investigation.
Okay. All right, so that makes sense. So it doesn't look like there's much of a dispute between the parties on this. So to that degree, I will grant the motion in limine to exclude the ultimate conclusion, at least on who forged the will and who actually caused the death of Mr. Donaldson. Anything further from the defense for motions?
No, that's it, Your Honor. We are ready to proceed with opening statements.
All right. Plaintiff, you may begin your opening statement whenever you are ready, and I will turn off my screen for that.
Yes, Your Honor. May I proceed?
Yes, you may.
He threatened divorce. She made him disappear. Let's go back to a hot, sticky day in August of 2012. Lou Donaldson is sitting in his office with his wife, Karen. He says, "Karen, we need to talk." He tells her that their marriage isn't working. She pleads with him, begs him to change his mind, says, "I can change." But Lou just shakes his head. "I'm filing for divorce." She stands up out of her chair, screams, and storms out of the office. Lou Donaldson is still sitting at his desk. He's shaken, but he's relieved. He thinks that his marriage is about to end. He doesn't know that his life is about to end. 2 weeks later, 2 weeks after Lou Donaldson told his wife he wanted a divorce, he was gone, disappeared. The evidence will show that Lou Donaldson left his office and went home on August 17th of 2012, the same home that he shared with his wife. Today, the evidence will show that she killed him, disposed of his body, and then waited to inherit $10 million. When he threatened divorce, she made him disappear. We represent the plaintiff in today's case, Cameron Donaldson. Lou Donaldson was her father. Today, she's suing the defendant, Karen Baja, for her father's wrongful death. That means we have to prove it's more likely than not that the defendant's conduct caused Lou Donaldson's death. Today, we're going to meet that burden by proving 3 simple facts. Lou Donaldson told the defendant he wanted a divorce. 2 weeks later, he was dead, and the defendant is the one that killed him. So let's take those one at a time. First fact that we're going to prove is that Lou Donaldson told the defendant that he was about to file for divorce. Today, you're going to learn that Lou Donaldson was a wealthy man. He owned a successful car dealership, multiple private planes. He owned lions and tigers and jaguars. The defendant and her husband enjoyed a life of luxury. But on August 3rd of 2012, the defendant learned that was about to change. You'll hear eyewitness testimony that on that day, Lou Donaldson told his wife that he was going to divorce her. Now, the second fact we're going to prove today is that 2 weeks after Lou Donaldson threatened to divorce the defendant, he was dead. Cameron Donaldson's going to take that stand today. She's going to tell you about the last time she ever saw her father. He was at work, 6 p.m. on Friday, August 17th of 2012. He said, "I'm headed home. I'll see you on Monday." He didn't come back on Monday or Tuesday or ever again. And when the defendant was questioned about it, she said, well, maybe he moved to Costa Rica. Today, you'll learn that Lou Donaldson never moved anywhere. His clothes, they were still hanging in the closet. His toothbrush was still in the sink, and not a penny was missing from his bank account. Today, the evidence will show that Lou Donaldson was dead. The third fact that we're going to prove today is that the defendant killed her husband. We questioned the defendant under oath. We asked her, "What were you doing the night that your husband disappeared?" She said, "I went out at 3 a.m. and met up with my brother, Carl." We asked her, "What were you doing out at 3 a.m.?" Her answer, I was buying milk. Today you'll learn that after the defendant met up with her brother Carl at 3 a.m. to buy milk, Lou Donaldson was never seen alive again. Now, I want to be clear. The police that investigated this case, they never found Lou Donaldson's body. They never found physical evidence, blood or DNA that pointed to the defendant. But today, you'll also learn that the deputy sheriff of that same department, it's the defendant's brother, Carl. Folks, some of the most important evidence that you're going to hear in today's trial is about how the defendant was acting after her husband went missing. You'll learn that when everyone else thought that Lou Donaldson was alive, the defendant was already acting like he was dead. She never called her husband and said, "Where are you?" She never texted her husband, "When are you coming home?" The evidence will show that the defendant didn't try to contact her husband a single time after he disappeared. Instead, the evidence will show that the same weekend he went missing, the defendant broke into his office, stole his financial documents, and then declared that she now owned all of his property. Members of the jury, it was just over 8 years ago that Lou Donaldson thought he was about to start a new chapter of his life. He never got that chance. That's why at the end of today's trial, we're going to ask that you find the defendant liable for his death. Because when he threatened divorce, she made him disappear. Thank you.
Thank you, counsel. Defense, you may begin your opening statement whenever you are ready.
Unseen, unknown, unanswered. Unseen. There is not a single eyewitness that will tell you that they saw Karen Baja kill Lou Donaldson. Unknown. There is no forensic evidence that a murder even took place here. There's no blood, no fingerprints, no DNA evidence. And in fact, the body of Lou Donaldson has never been found. Unanswered. We have absolutely no idea what happened to Lou Donaldson. And neither does the plaintiff. But what we do know is that Karen Baja did not kill Lou Donaldson. And the plaintiff most certainly cannot prove that she did. Now, it is the plaintiff's burden to prove this to you. It's their burden to prove to you that Karen Baja killed Lou Donaldson. And members of the jury, they will not meet that burden here today. My name is Catherine Patton, and I, along with my co-counsel, Ryan Chancellor, represent Karen Baja in today's case. Now, you're going to hear a lot about Karen, so I'd like to introduce you to her. Karen is an owner at Wild Wildlife, and she's dedicated her whole life to protecting animals. It was her passion, and this was a passion that she shared with her longtime husband, Lou Donaldson. Now, Karen and Lou met completely unexpectedly. Neither one of them was looking for a relationship, and in fact, Lou was already married and had a daughter, Cam Donaldson, who is the plaintiff in today's case. Now, they absolutely fell in love. They both learned very early on that they shared something. They shared a passion for tigers and big cats. They were soulmates. And so together, they built not just a marriage, but also Wild Wildlife, a tiger and big cat rescue. Now, of course, you will learn that their marriage wasn't perfect. Like most marriages, it wasn't happy 100% of the time. At one point, Lou did attempt to obtain a temporary restraining order against Karen, and there was even some talk of divorce. But they never gave up. They never gave up on their marriage or on their business. One day in August of 2012, Karen was busy taking care of some newborn cubs. The mother had rejected them, so you see, she was working round the clock. And when she realized that she was almost out of supplies, she immediately went to the store, even if it was 3 o'clock in the morning. But little did she know that this very day would be the last day that she ever saw her husband, Lou Donaldson. Because Lou never came home. And you will hear that she waited. She waited for days. And then those days turned into weeks. And those weeks turned into months. She will tell you that she waited for years for Lou to come home. She waited for years just hoping and praying that Lou would walk in through that door. And you will hear that she pushed through this devastation every single day. And she continued to do what her and Lou had dedicated their entire lives to, running the big cat rescue. Five years went by, and no one had heard from Lou. With each passing year, Lou's return was getting more and more unlikely. Questions were left unanswered, rumors spreading like wildfire. So Karen decided it was time. It was time to move forward. It was time to bring some closure to this tragedy. And so Karen made the most difficult decision that she's ever had to make, to give up hope and to have her husband, Lou Donaldson, declared legally dead. Now, with this, Karen was able to receive the money that it would take to keep Wild Wildlife up and running. Now, Karen inherited $5 million from Lou's life insurance policy and $5 million from Lou's estate. Now, she will tell you that Lou wanted her to have this money. He wanted her to have this money so that she could continue running what they had built together from the ground up, Wild Wildlife. And members of the jury, she got the money in this case because Lou's last will left it to her. Now, you will hear that the plaintiff is questioning whether or not that signature on the will was forged. But members of the jury, Chris Renard, the guy who worked for the insurance company who investigated the insurance claim, looked into that will, and he found absolutely nothing wrong with it. And at the end of the day, that claim was upheld and the money was paid out. What happened to Lou Donaldson is a tragedy for everyone. But members of the jury, it's also a mystery. What happened to Lou Donaldson is unknown. Now, at the end of this trial, we will come before you again. And at that time, we will summarize for you what the evidence in this case showed. But more importantly, what the evidence in this case didn't show. And you will learn that the plaintiff will leave you with many unanswered questions. Where are the eyewitnesses? Where's the forensic evidence? And where is the body of Lou Donaldson? There will be no evidence that Karen Baja had anything to do with the death of Lou Donaldson. Now, based upon the lack of evidence brought forth by the plaintiff, we will ask that you find the defendant, Karen Baja, not liable.
Thank you, counsel. All right. Plaintiff, you may begin your case in chief.
Plaintiff calls Cameron Donaldson. May I proceed?
You may.
Good evening.
Good evening.
Can you see and hear me okay?
I can.
Please introduce yourself to the jury.
Hello, my name is Cameron Donaldson.
Where do you live?
I live here in Pioneer. I've lived here my whole life.
Did you know Lou Donaldson?
Yes.
How?
He was my dad.
Do you know the defendant, Karen Baja?
Yes, she was my stepmother, my dad's second wife.
Ms. Donaldson, why did you bring this case?
In 2012, I overheard my dad tell Karen he was going to divorce her. 2 weeks later, he had disappeared. The day after he went missing, Karen smiled at me. She said, "I won." And she told me that everything my dad owned was about to be hers.
Let's start at the beginning. In your electronic notebook, could you find the document called Donaldson Deposition Exhibit 1? It's on page 27.
I see it.
What is it?
It's a photo of dad. It's my favorite photo of him. It was taken when I was younger.
Your Honor, we offer this as Plaintiff's Exhibit 1.
Any objection?
No objection, Your Honor.
This is admitted as Plaintiff's 1.
Permission to publish on screen.
You may.
Now, Ms. Donaldson, you said that it's been 8 years since you last saw your dad. How has that affected you?
It's hard to put into words. I miss him so much that I think about him every day.
Were the two of you close?
Very close. We had dinner together a lot. I also worked with him every day for 20 years.
What did your dad do for a living?
Dad had a business selling cars, but his real passion was animals. When he had saved up enough money, he bought a big cat sanctuary. Lions, tigers, leopards. I helped him run it.
What was that big cat sanctuary called?
Wild Wildlife?
Ms. Donaldson, were you here during the defense's opening statement?
I was.
In their opening statement, they said that your dad and the defendant built Wild Wildlife together. Was the defendant an owner of Wild Wildlife?
No, Karen worked there. She helped with the animals, but it was my dad's business. I have been working with him for 20 years. He started it in 92. So no, she wasn't an owner.
I want to talk about what you said earlier. You said that in 2012, you heard your dad tell the defendant that he wanted a divorce. Now, when exactly was that?
It happened twice.
When was the first time?
In June of 2012,
What exactly did you hear your dad say?
Dad said he wanted a divorce.
When he told the defendant that he wanted a divorce, how did she react?
She screamed at him. She screamed at him in his office, then she stormed out.
Hearsay, Your Honor.
Wants to hearsay?
Your Honor, any statements which were not elicited, but if there were a statement elicited, it would be a declaration by a party opponent.
I believe that's where he was going. Is there something else other than that, Ms. Patton, that you were objecting to based on hearsay?
No, Your Honor.
Objection is overruled.
So let me get this straight. In June 2012, you heard your dad say that he wanted a divorce. And what did the defendant do?
In June, he said he wanted a divorce. And she said, "If you try to divorce me, I will kill you." In June.
You said that there was a second time when you heard your dad talk about divorce. When was that?
That was on August 3rd of 2012.
Where were you?
We were at the office, me, my dad, and Karen.
When you were at the office on August 3rd, what did you hear your dad say?
Dad said he had made up his mind that he was going to file for divorce.
And when your dad told the defendant that he was going to file for divorce, how did she react?
That's when she screamed. She screamed at him, then she stormed out of her office.
Ms. Donaldson, you said earlier that your dad disappeared. After he told the defendant that he'd made up his mind and was going to file for divorce. When was the last time you saw him?
It was Friday, August 17th, exactly 2 weeks later.
What time was it?
6 p.m., Dad was leaving the office.
As your dad was leaving the office at 6 p.m. that evening, did he say anything about his upcoming plans?
Yes, he said he was going to spend the weekend at home. He said, "I'll see you on Monday." Those were the last words that Dad ever said to me. "I'll see you on Monday."
Now, I want to talk a little bit more about your dad. Did he have any passions?
Yes, he did.
What was something that he used to do?
Dad loved to fly.
You said that he used to fly. Did he own planes?
Yes, he owned planes. He owned multiple, but I can't remember exactly how many.
Where did he used to go?
He would go back and forth to Costa Rica sometimes.
Did you know when he was going?
Dad would always let me know that he was heading out, so yes.
Now, back in 2012, did you have access to your dad's financial records at all?
Yes, both his business and personal accounts.
In your electronic notebook, could you find the document called Bank Account Statement? And let me know when you found it. It's on page 54.
I found it.
What is it?
This is Dad's bank account statement from 2012 through 2017. It covers the 5 years after I last saw him.
Your Honor, this document comes with a business records certification from the bank manager of Statesville Bank. We offer it into evidence as Plaintiff's Exhibit 2.
Any objection?
Yes, objection. Yes, Your Honor, objection to foundation.
I believe, well, I'll let you respond, Mr. Ayers. The foundation.
Your Honor, I believe this witness has already testified that she had access to his financial information, including his bank records. She's seen this document before, that it shows the bank records from 2012 to 2017. And as I said, it comes with a certificate of authenticity from the bank manager at Statesville Bank. I believe I've laid all the requisite foundation.
May I respond, Your Honor?
Just briefly.
Briefly. Your Honor, we aren't sure how she had access to this document and where she's seen this document before. I don't believe that the proper foundation has been laid for this piece of evidence to be admitted through this witness.
Okay. I'm going to admit this exhibit as Plaintiff's 2. Looking at this exhibit, looks like there is a 902.11 authenticity statement that would satisfy 803.6. As far as the additional foundation, Ms. Patton, of course, on cross-examination, you were free to cross-examine Ms. Donaldson on how she came to know what this statement said.
Yes, sir.
Your Honor, may we publish Plaintiff's Exhibit 2 on screen?
You may.
Mr. Trevisani, could you zoom in on just the financial portion of that document? Ms. Donaldson, what activity does your dad's bank account statement show after he disappeared in 2012?
None. Before that, you can see that Dad was making deposits or withdrawals every few days. But after August 17th, it just stopped. No deposits, no withdrawals, nothing.
Now, where did your dad live?
Dad lived here in Pioneer. He lived at 5514 Colliers Drive.
And who lived with him?
Just Karen.
I want to talk about the defendant. You said that you last saw your dad on August 17th, 2012. But when was the next time you saw the defendant?
2 days later, August 19th at 6 a.m.
Why did you see the defendant at 6 a.m.?
The alarm went off at Dad's office. I live close by, so I just drove right over.
And can you tell the jury what you found when you arrived at your dad's office?
The padlock on the front gate was cut. I also saw 2 people coming out of the office.
I want to start off by talking about that physical damage that you discovered. In your electronic notebook, could you find the documents called Donaldson Deposition Exhibit 2 and Donaldson Deposition Exhibit 3? They should be on pages 28 and 29, respectively.
I found it.
Do you recognize these photographs?
I do.
What's the one called Donaldson Deposition Exhibit 2?
Exhibit 2 is a photo of the padlock on the front gate at Dad's office.
And what's Exhibit 3?
It's the gate outside the office.
When you arrived at your father's office on August 19th, is that how the padlock and the gate looked?
Yes.
Your Honor, we offer the photograph of the lock into evidence as Plaintiff's Exhibit 3.
Any objection to Exhibit 3?
No objection, Your Honor.
It's admitted.
And we offer the photograph of the gate as Plaintiff's Exhibit 4.
Any objection to Exhibit 4?
No objection, Your Honor.
Is admitted, and counsel, you can publish both 3 and 4.
Thank you, Your Honor. Now, Ms. Donaldson, you said that when you arrived at the office on the 19th, that's what the padlock looked like. Is that what it looked like when you left on the 17th?
No, on the 17th, it was still intact.
What about the gate? Is that what it looked like when you left on August 17th?
No, the gate too was intact when I left.
Thank you, Mr. Trevisani. Now, Ms. Donaldson, you said that when you arrived, you also saw 2 people leaving your father's office. Did you recognize them?
The one person coming out, I didn't. He was carrying a bolt cutter. The other person was Karen. He was carrying a lockbox.
Had you seen that lockbox before?
Yes, it was the lockbox from Dad's office. He kept important documents there.
And when you saw the defendant leaving your dad's office holding that lockbox, what was her demeanor?
She was smiling, ear to ear.
Did she say anything to you?
She said, I won. She told me my father was gone and that everything that Dad owned was about to be hers.
When the defendant told you that she'd won, that your father was gone and everything he owned was about to be hers, how long had it been since you'd last seen your dad?
Less than 2 days, 36 hours.
Thank you, Your Honor. No further questions at this time.
Counsel. Ms. Patton, your cross-examination.
Yes, Your Honor. Now, Ms. Donaldson, you hate Karen Baja, right?
Yes,
In fact, you hope that she gets attacked by one of her tigers and eaten.
I said that out of anger in the past. I didn't mean any Karen any harm, but yes, I have said that.
Now, that's the same person that you were talking about that you're suing in this case, correct?
That's correct.
And the lawsuit that you brought today is alleging that she killed your father.
It's a wrongful death suit, but I do feel that she's responsible for my dad's death.
Okay, let's talk about that. Now, you're not aware of any eyewitnesses that ever saw Karen kill your father, correct?
No, I'm not.
You're not aware of any fingerprints found.
No,
You're not aware of any DNA.
no physical evidence.
And isn't it true that your father's body was never recovered in this case?
Unfortunately, yes.
Now, I want to talk to you about your role at Wild Wildlife. Now, you just were talking about how you worked closely with your father, right?
Yes, very closely for 20 years.
You scheduled his meetings.
I did.
You ordered all the supplies.
I did. That was a part of my duties.
And you had some more duties too. You also wrote the checks, right?
I did.
And you ran the books at the business.
Yes.
So it's fair to say that you did it all at Wild Wildlife.
I did. I did quite a bit. Yes.
Now, when your dad went missing, you didn't take over the business.
No, I didn't.
Karen took over the business, right?
She did.
Now, being so involved in the business, you also know that it was worth quite a bit of money, right?
Yes, Dad had built a very successful business, one of many.
Oh, I'm sorry. Yeah, very successful. It was worth $5 million to be exact, right?
Yes, that's correct.
And you also know that he had a life insurance policy that was worth another $5 million.
Yes, he did.
So altogether, that's $10 million, right?
That's correct.
Now, you didn't get the $5 million from the life insurance policy, did you?
No, that was awarded to Karen.
Now, you also didn't get a cut of the $5 million business, right?
No, I didn't.
Because he left it all to Karen in his will?
In the will that she presented, yes.
Yeah, the will that she presented. Now, you claimed the will that she presented had a forged signature, right?
I didn't exactly claim that, just that I saw the lockbox that she took from my dad's office, and that's where his will was kept.
Yeah, so you claimed that there was a different will than the one that Karen presented.
Yes.
A will that included you.
Yes, it did.
You don't have any record of this will?
The only record of the will was in the lockbox that she took on August 19th.
So you don't have a picture of it?
No, I don't.
You don't have a copy of the will?
No, it was just that one copy.
So the jury just has to take your word for it that there ever even was a previous will.
Yes.
Now, you claim that the old will, the one that included you, was inside the lockbox at Wild Wildlife.
That's correct.
One day, the alarm went off at Wild Wildlife.
It did.
It was around 6 in the morning, right?
Yes, it was.
You live close by, so you went there.
I did.
And the police drove in right behind you.
The police did.
Once you got there, you saw Karen Baja leaving Wild Wildlife
Yes, with the other gentleman.
with the other gentleman. And now Karen Baja, in her hands, had that lockbox, right?
She did.
The lockbox that you said had the other will inside of it.
That's correct.
But you didn't tell the police about the will that day, did you?
The police questioned Karen.
Directing you back to my question, you did not tell the police that day about Karen having the will.
No.
You didn't go to the police station the next day to tell them that Karen had the will.
I did not.
I just want to clear a few things up, Ms. Donaldson. Now, your dad disappeared in 2012.
He did.
You hired an investigator to look into the disappearance of your father
I did in 2017.
in 2017. So when you found out your dad disappeared, you didn't hire an investigator the next day.
No, I hired Taylor Pride in 2017.
In 2017, so that was 5 years after your father disappeared.
That's correct.
Now, I want to talk to you about the investigator that you hired. Now, the investigator never told you that he found any witnesses, right?
No, Taylor did not.
He never told you that he found any forensic evidence.
No, no forensic evidence was found.
He never found your dad's body, right?
Unfortunately, no.
May I have a moment, Your Honor?
You may.
Nothing further, Your Honor.
Thank you, Ms. Patton. Mr. Ayers, any redirect examination?
No redirect, Your Honor. May this witness be excused?
She may. And the plaintiff, you may call your next witness.
Yes, Your Honor. The plaintiff calls Taylor Pride to the stand. May I proceed?
Yes.
Good evening. Yes, Your Honor. Good evening, Ms. Pride. Can you see and hear me okay on your screen?
I can.
Please introduce yourself to the members of the jury.
My name is Taylor Pride, and that's spelled Pride.
What do you do for a living?
I'm a private investigator.
How are you involved in today's case?
Well, I was hired by Miss Cam Donaldson to investigate the disappearance of Lou Donaldson.
Before we talk about the evidence, I want the members of the jury to get a better sense of your credentials. How long have you been working as an investigator?
I've been an investigator for 20 years now.
Where have you worked?
Well, for the first 16, I worked for the Pioneer Police Department, and then for the last 4, I've been a private investigator.
Okay. Do you have experience examining financial documents?
I do. I've investigated a lot of economic crimes, so that involves examining a lot of financial documents.
Do you have experience investigating disappearances?
Yes, I do.
Do you have experience investigating homicide?
Yes, I do.
Do you have formal training investigating each of those things?
Yes, I received formal training through the police academy and as part of work in my job.
So let's talk about your work in today's case. What evidence did you have to review?
Well, I reviewed witness accounts as well as financial documents and even some photographs.
You mentioned financial documents. Which documents did you review?
I looked at the bank records of Lou Donaldson, as well as a report from the life insurance company and the will that was produced by the defendant shortly after Mr. Donaldson disappeared.
Okay. Now, you mentioned witness statements. Did you have access to a statement from the defendant herself?
I did. I reviewed her statement from the deposition.
Okay. So I want to talk about what you found. Now, does she say when her husband went missing in that deposition?
She does. She said that he went missing on August 17th of 2012.
In her sworn statement, does the defendant offer an explanation for her husband's disappearance?
She does. She said that he may have moved to Costa Rica.
Did you investigate that possibility, ma'am, that Lou Donaldson moved to Costa Rica?
Yes, I did.
How did you go about determining that?
Well, I looked at Lou Donaldson's bank records, and then I also sent an investigator down to Costa Rica.
What evidence did you review that Lou Donaldson had in fact moved to Costa Rica?
None.
You mentioned a bank record. Which bank record was that, ma'am?
That was Lou Donaldson's bank statement for the 5-year period after he went missing.
Would you recognize it here in court today?
Yes, I would.
Your Honor, may we republish to the screen Exhibit 2? It's already been entered into evidence.
Yeah, if it's already been admitted, you can just publish it and let me know that that's what you're doing.
Yes, Your Honor. Now, Ms. Pride, you see the bank statement on your screen?
I do.
So when you were investigating this possibility that Lou Donaldson moved to Costa Rica, how did this factor into that analysis?
Well, I wanted to see if he'd made any big withdrawals or if he'd made any transfers of his assets or if he even started spending money in Costa Rica.
So after August 17th of 2012, how much money did Lou Donaldson spend in Costa Rica?
Not a single dollar.
Before August of 17th of 2012, are there deposits and withdrawals in this statement?
Yes, before the date he went missing, you can see there are many withdrawals and deposits.
After August 17th of 2012, how many deposits are on that statement, ma'am?
None.
How many withdrawals?
None.
Okay, so I want to put that aside for a moment, ma'am. And I want to ask, did you consider any other explanations that might explain Lou Donaldson's disappearance for your work in this case?
Yes, I did.
What other possibilities did you explore?
I also looked at the possibility that the defendant, Karen Baja, killed Lou Donaldson.
So let's start with motive then. According to the defendant, where does she say she was the night that her husband went missing?
Well, she says that she went out to get some milk
What time?
at 3 a.m.
Who, if anyone, does the defendant say she saw when she was going out for milk in the middle of the night?
She says that she saw her brother when she was out for milk.
Now, ma'am, for your work in this case, did you ever have knowledge of what the defendant's brother does for a living?
Yes, I learned that he is a sheriff's deputy.
Now, do you know which law enforcement agency investigated Lou Donaldson's disappearance, ma'am?
Yes, the same sheriff's department where the defendant's brother works.
Okay, I want to ask about the defendant's behavior after her husband went missing. Does the defendant say that she called her husband on August 17th of 2012?
No, she didn't call him.
Does the defendant say that she called the police?
No, she didn't call them either.
According to the defendant, what was the first thing she did after her husband went missing?
The first thing she did is she went to her husband's office where he kept his will.
Thank you, Ms. Pride. Your Honor, we have no further questions at this time.
Thank you, Mr. Trevisani. Mr. Chancellor, your cross.
Yes, Your Honor. Now, Ms. Pride, I just want to talk about something that we just heard on direct. Now, you mentioned that as a part of your investigation, you reviewed the bank statement,
Yes, I did.
and you noted that there was never a deposit or withdrawal made after August 17th, 2012.
Yes, that's correct.
And you are aware that the total in that account hovers around $100,000.
Yeah, that sounds about right.
Now, you're also aware that Lou Donaldson is a millionaire.
Yes.
Now, Ms. Pride, you consider yourself an experienced investigator.
Yeah, I've been doing it for 20 years, so I would say so.
And for 16 of those years, you worked with the Pioneer Police Department as a detective, right?
Yes, I did.
And during your 16 years as a detective, you served the public.
Yeah, I guess you can say that.
Now, a short while ago, you left the police force and started your own private investigation firm, correct?
I did.
And as a private investigator, you're hired directly by clients.
Yes.
And in this case, your client was Cam Donaldson.
Yep.
Cam Donaldson paid you for your investigation.
Yeah, she did.
Now, I want to just talk a little bit about that investigation. Now, you would agree with me, someone with so many years of experience investigating, that it's important to conduct complete and thorough investigations.
Yeah, of course.
That it's important to collect every single piece of relevant evidence.
Yep.
That it's important to talk to all eyewitnesses
As many as I can.
and come to a conclusion based on the facts.
Yes.
But in this case, you didn't do that.
I don't agree with that, but okay.
Well, let's talk about that then. You were hired by Cam Donaldson to investigate the disappearance of Lou Donaldson, correct?
Yes, I was.
And Lou, you were hired in 2017.
Yes, that's correct.
Now, you're aware that Lou Donaldson disappeared in 2012.
Yes, I am.
So you weren't hired until 5 years after Lou's disappearance.
Right.
And as a part of your investigation, you were tasked to look into Lou Donaldson's last will and testament.
Yes, I was.
Now, you questioned the authenticity of that last will and testament.
I do.
And that conclusion is based on your analysis of the handwriting, correct?
Objection, Your Honor. Relevance and confuses the issue under 403.
Explain a little bit further, Mr. Trevisani, obviously outside the presence of the jury.
Yes, Your Honor. This witness in her expert report, did conclude that the will at issue is a forgery. But we did not offer that conclusion on direct examination because this is a wrongful death case, not a probate case. So for defense to undermine a conclusion that isn't being presented is both irrelevant under Rule 401 and confuses the issues under Rule 403. The members of the jury may think that this will is central to what we're trying to prove today, and it just isn't.
Response, Mr. Chancellor?
Yes, Your Honor. First of all, the bar for 401 is extremely low. Any tendency to make any fact more or less probable. For that reason, it is directly relevant because it goes directly to the credibility of this expert's investigation into the surrounding circumstances of Mr. Donaldson's disappearance. And credibility is always relevant on cross-examination.
I guess, Mr. Chancellor, this was not offered during the direct examination. So to some degree, it's outside the scope of the direct for this cross. Can you explain to me a little bit more on, I guess, how getting into the examination of the signature and that area of cross-examination, how that goes to the credibility of her investigation of what that undermines?
Yes, Your Honor. First of all, the fact that the opposing counsel didn't dive into the entirety of this witness's investigation does not automatically shield them from a cross-examination into the complete circumstances of that investigation. As a part of this investigation into the forgery, if this witness on direct examination, or not this witness, I apologize, the plaintiff Cam Donaldson during her direct examination testified about the missing lockbox and the existence of a previous will. This expert was hired to look into the authenticity of that will. The plaintiff cannot simply shield the members of the jury from hearing about the entirety of this expert's investigation by choosing not to bring it up on direct examination.
I guess the hard part I'm having is you're going to cross-examine on her comparison of the signature being accurate. Isn't that the exact opposite point of what I'm assuming you're trying to prove as the defense?
Your Honor, this line of questioning is going to undermine the overall credibility of this expert's investigation in its entirety.
Okay. I'll give you a little leeway, Mr. Chancellor, and I'll see where you go. Doubtful as far as the relevance of it, given that the plaintiff decided not to proceed with this evidence whatsoever on their direct examination, because I didn't hear anything about it. So I'll give you a little bit of latitude, but if it gets too far down the line, Mr. Trevisani, feel free to re-object and we can address it at that point.
Yes, Your Honor.
Yes, Your Honor. Now, Ms. Pride, I just want to back up a little bit. And you did question the authenticity of the will, correct?
Yes, I did.
Now, as to Karen specifically, as a private investigator, well, let's back up even farther, actually. As a private investigator hired by Cam Donaldson, you've had conversations with Cam Donaldson about her side of the story, correct?
Yes, I have.
And you worked to confirm her side of the story.
I worked to uncover the truth.
Now, part of that investigation was into Miss Donaldson's claim that the lockbox was stolen from her father's office.
Yes, that was something I looked into.
And that in that lockbox was a will.
Yes.
Now, apart from your conclusion that the will was not authentic, I want to focus on Karen. At no point in time did you collect any handwriting samples from Karen Baja?
No, I didn't.
And at no point in time did you compare any of Karen's handwriting to the writing on the will?
No, I didn't.
Objection, Your
Thank
Honor. Under 403, if I may be heard.
Is this kind of the same type of objection that you made previously?
Similar, Your Honor, but also pursuant to your pretrial ruling, if I may be heard outside the presence of the jury.
May.
Your Honor, one of the conclusions that you specifically excluded during the pretrial motions was that the conclusion as to who forged the will was specifically excluded. And it appears that opposing counsel is attempting to get into that conclusion, although it's already been categorically excluded from today's trial. And we believe that this might further confuse the members of the jury along the same lines as my previous argument.
Your Honor, if I may respond.
Go ahead.
First of all, at no point in time did I ask this witness to make a conclusion on who actually forged the will. I asked this witness about specific acts in her investigation that she neglected to do. It is directly relevant to the credibility of the investigation and does not in any way trample the pretrial ruling into a specific conclusion.
I don't think at this point I've heard a question asked or an answer given that the defendant was the one, or anybody else for that matter, forged the will. So I don't believe that my pretrial ruling has been violated at this point. So I'm going to overrule the objection. You may continue, Mr. Chancellor.
Now, Ms. Pride, I want to talk about your characterization of the investigation into the disappearance of Mr. Donaldson.
Okay.
Now, you claim that the investigation performed by the Sheriff's Department was faulty.
Yeah, I think they could have done a better job.
And you base that opinion on the fact that they never recovered Mr. Donaldson's body.
That was part of it.
And they couldn't produce any evidence of foul play.
Yeah, that contributed to it.
Now, over the course of your investigation, you never collected any DNA evidence.
No, there was no DNA evidence. I mean, there's no blood, no DNA, anything.
You never tested for it.
No, there wasn't any.
Ms. Pride, you also never spoke to any eyewitnesses who saw what happened to Lou Donaldson the night of August 17th?
Other than Cam Donaldson, no, to my understanding, there were none.
I just want to back up a minute. It's your testimony here today that Cam Donaldson witnessed what happened to Lou Donaldson on the night of August 17th, 2012?
No, not specifically what happened to him. I just spoke to Cam Donaldson about what she witnessed that night.
So to answer my question, you spoke to no eyewitness who saw what happened to Lou Donaldson.
No, I didn't.
And you yourself never collected Mr. Donaldson's body.
No, I didn't.
No further questions.
Thank you, Mr. Chancellor. Any redirect examination?
No redirect, Your Honor. May Ms. Pride be excused?
She may. Is there any further evidence or witnesses that the plaintiff would like to present?
No, Your Honor. With that, the plaintiff rests our case in chief.
All right. Any motions from the plaintiff at this time?
Your Honor, we as the plaintiff have no pretrial motions or mid-trial motions.
Thank you. And any motions from the defense at this time?
Yes, Your Honor. If I may be heard.
Yes.
Pursuant to the Federal Rule of Civil Procedure 50, at this time, the defense moves for a directed finding in favor of the defendant, Karen Baja. First of all, over the course of the plaintiff's case in chief, at no point in time was there an in-court identification of the defendant, Karen. Additionally, during the opening statement, counsel confused the actual elements in the case and considered that they had to prove three things. They had to prove that he told her he wanted a divorce, that he is dead, and that Karen killed him, which are not the elements that they have to prove in today's case. Additionally, they have no direct evidence linking Karen Baja to any intentional act, reckless act, murder weapon, time, date, how, when, where, nothing of when the so-called killing actually occurred. And for those reasons, when viewing the evidence in the light most favorable to the non-moving party, as this court is required to do, the plaintiff has failed to produce sufficient evidence such that a reasonable jury could find for the plaintiff, and we ask that a directed finding be entered in favor of Karen Baja.
Thank you, Mr. Chancellor. Any response from the plaintiff?
Yes, Your Honor. First, we believe that the record will show that opposing counsel has mischaracterized our opening statement. We didn't say that those were our three elements. We said that those are the three facts that we're going to prove that allow us to meet our burden in today's case. And this motion from the defense should be denied because viewing the evidence in light most favorable to the plaintiff, a reasonable jury could find that we've met that burden. Our claim of proof requires 3 elements. First, a reasonable jury here could conclude that Lou Donaldson was dead. He hasn't been seen or heard from in 8 years. His bank account ceased the activity the night he went missing. Second, a reasonable jury could conclude that the defendant caused his death. As the only person who benefited, who received $10 million, she's the only person with motive in this case. Now, the night that Mr. Donaldson disappeared, the defendant admits to leaving her home. She met up with her brother under circumstances that could charitably be described as implausible. And perhaps most telling is her behavior after Mr. Donaldson went missing. When Mr. Donaldson had only been gone for 36 hours, the defendant declared that she owned all of his property and that because she knew he was dead, a reasonable jury could conclude that she knew that because she killed him. Our final element would be damages. And of course, Your Honor, a daughter experiences loss when her father is killed. So we've met our burden for this case to go to the members of the jury.
Thank you, Mr. Treversani. I'm sorry if I keep mispronouncing it. I'll get it by the end of the trial. But to no one's surprise, I'm going to deny this motion. We will proceed with the defense's case in chief after we take a recess. I show it as at least Mountain Time, 7:07. So we will begin the defense's case in chief at 7:15 p.m. Mountain Time. So I will see everyone back in about 8 minutes. And while we're doing that, if we can get a time check, if the timekeepers kind of figure out the time, and we'll get that. All right. We can get the parties back on screen. We have, and if you guys see in the chat, we have the time check. Plaintiff has 44 minutes left and the defense has 52 minutes left. And with that, it is 7:15 here, and we will begin the defense's case in chief. Defense, you may call your first witness.
Thank you, Your Honor. The defense calls Chris Renard to the stand. May I proceed, Your Honor? Good evening. Could you please introduce yourself, spelling your last name for us?
Yes, good evening. My name is Chris Renard, R-E-N-A-R-D.
Where do you work at, Mr. Renard?
Currently, I work for the Summit Life Insurance Company.
How long have you worked at Summit Life Insurance Company?
I've worked for Summit for about 20 years now.
And at Summit Life Insurance Company, what is your current job title?
So currently, I'm an investigator and a forensic document examiner.
Can you just briefly explain to us what a forensic document examiner is?
Yeah, so forensic document examiner means that I have specialized training in handwriting and signature identification. And the main thing that we do there is look at potentially fabricated documents and altered records and try to determine whether they're real or not.
Now, I want to talk to you about how you became an investigator and forensic document examiner. Where did you go to college?
I went to college at Summit College and I got a Bachelor of Arts in Criminology.
Did you go anywhere after that?
I did. After I graduated from Summit, I attended the Statesville Police Academy.
Did you graduate from the Statesville Police Academy?
I did, yes.
Now, after you graduated, what did you do?
Right after getting out of the police academy, I was hired by the Statesville Bureau of Investigation. And at the Bureau of Investigation, I was a crime lab forensic document examiner.
Now, how long were you working in the crime lab?
I worked for the crime lab for about 3 years.
And after 3 years of the crime lab, did you take a job somewhere else?
Yes. After that is when I transitioned into working for Summit Life Insurance, and I've been there for the last 20 years.
Now, will you just tell us a little bit about what you do as an investigator and forensic document examiner at Summit Life Insurance Company?
Yeah, of course. So at Summit, we are an insurance company, and that means that sometimes insurance claims comes in and there are some things that seem a little bit off about them. So my job as an investigator is to look through the documents and the surrounding circumstances of a particular claim and make a determination regarding whether or not the company should pay out on a claim or not.
Did you investigate the insurance claim for the life insurance policy of Lou Donaldson in this case to see if that claim should be paid or not?
I did.
Now, before we talk about that, I just want to get a little bit more details about your qualifications as an investigator and forensic document examiner. Is there anything that you specialize in?
Yes. So specifically, I specialize in document examination.
Do you have any certifications?
I do. I'm certified by the Board of Forensic Document Examiners and the Association of Certified Fraud Specialists.
Now, in connection with your profession, have you participated in any types of continuing education?
I have, yes. Summit allows us to go to annual training workshops, and we continue to keep our certifications up to date. So pretty much every year I get continuing education regarding handwriting and document examination.
Have you testified as an expert before?
I have. I've testified about 25 times.
Now, do experts in your field use certain practices and methods that are followed when you're doing these types of investigations?
We do, yes.
And now, when you come to conclusions in these investigations, do you base those conclusions on practices and principles that are used in your field?
Absolutely.
Your Honor, pursuant to Federal Evidence 702, the defense tenders Chris Renard as an expert in the fields of insurance claim investigation and forensic document examination.
Mr. Framisani, any voir dire or objection?
No objection to this witness being confirmed as an expert, Your Honor.
Right. So admitted.
Now, Mr. Renard, earlier you said that you investigated the insurance claim for the life insurance policy of Lou Donaldson. Now, just generally speaking, why did you investigate that claim?
So generally speaking, my boss asked me to. He said that there were some irregularities that came up in the claim, some discussion about whether the beneficiary, Miss Baja, was involved in Mr. Donaldson's death. And he also asked me to look at the last will and testament because there was some allegation that it was a forgery.
Now, why did you look into Lou Donaldson's last will and testament?
I looked to the last will and testament because there were allegations that Miss Baja had forged that document.
Now, I want to talk to you about your analysis of the will. What was your first step in determining whether or not this will was valid?
Objection, Your Honor. At this time, the defense re-raises our objections under 401 and 403, if I may be heard.
But
Your Honor, we as the plaintiff are not contesting the authenticity of this will. This will, which the defense contends is legitimate and gave her $10 million, we agree. We think that the $10 million that she received, that's actually key to showing motive in this case. And we think continuing to go down this line of questioning to undermine a conclusion that we did not offer and do not plan to offer has potential to confuse the members of the jury into thinking that that's something that we're claiming and that's something that is critical to our case.
I guess I'll ask Ms. Patton. It seems like the plaintiff is willing to stipulate that the will and the last will and testament is in fact an authentic last will and testament, as Ms. Baja claims. Is that a stipulation that you are willing to accept?
Yes, Your Honor, but also, so today the plaintiff has to show an intentional or reckless conduct in this case, and forging the will is an intentional step that she took because she wanted to cause his death so that she can inherit everything. So that is what they're claiming, and their expert witness did in fact say that the will was not that the will was. I'm confused now. Their expert witness did say that the will was forged, and now having this expert testify as to the authenticity of the will goes to rebut the plaintiff's theory of Karen's motive.
Okay. Well, I'll say this. Ms. Patton, if you want to accept what I took as a willing to stipulate that the will is in fact the genuine will, I will accept that stipulation and not let you get into this testimony because I mean, you're getting into it and it's stipulated to. But of course, as the defense, you are not required to accept any stipulation by the plaintiff at all if you don't want to. And I guess I will leave it up to you. If you don't want to stipulate that it is in fact a valid will, you don't have to, and you can ask the questions, or you can accept that stipulation and you can address other issues with this witness. I'll leave it to you.
Yes, Your Honor, I will go ahead and stipulate to that.
Okay.
Now, Mr. Renard, paying out a life insurance policy, is it important to confirm if the person on that policy is in fact deceased before you pay it out?
Yes, it's very important to confirm that someone is actually deceased, especially on life insurance policies, because if I start paying out life insurance policies on people who are still living, it's very likely that I would lose my job.
As an insurance investigator, do you confirm that the beneficiary of the claim didn't actually cause the person's death?
Yes, at Summit, if the beneficiary of a life insurance policy was involved or caused the death of the person whose will or estate they were receiving, that would be grounds for us not to pay out a claim.
Now, let me ask you this. Do you have any contacts at the sheriff's office, Mr. Renard?
I do, yes.
And did you learn of any evidence suggesting that Karen Baja killed Lou Donaldson?
I did. I did not. As I was looking into the surrounding circumstances as part of my investigation, I reached out to my contacts at the sheriff's department, and they said that, or they indicated to me that there was no evidence of foul play.
Objection, Your Honor. Hearsay.
Response, counsel.
Your Honor, this is an expert, and or any hearsay statements that he relied on are admissible. And he did in fact rely on these hearsay statements when coming to his conclusion.
May I respond?
Go ahead, Mr.
Your Honor, pursuant to Rules of Evidence 703, this witness can certainly rely on otherwise inadmissible evidence to come to his conclusions. But in order to present that evidence before the members of the jury, opposing counsel faces a reverse 403 test. They have to show that it is substantially more probative than it is prejudicial. And in this case, he's talking about anonymous contacts from the police department. He's not giving us names, people that we can't cross-examine, testimony that we can't corroborate. So the prejudicial value of this is incredibly high, and the probative value of this anonymous source is very low. So we don't believe that this meets that reverse 403 test for him to actually talk about these statements, the underlying hearsay statements, in front of the members of the jury.
Ms. Patton, can you address the probative value of the jury hearing this information? I certainly heard from Mr. Trevisani about the prejudicial effect he believes it would have, but describe for me that probative value.
Yes, Your Honor. So this has high probative value because this goes directly to Chris Renard's job as an insurance claims investigator, and it shows the steps that he took and what he did in his investigation when deciding whether or not to pay out the life insurance policy claim.
Understanding and noting the 703 objection, I am going to allow Mr. Renard to testify to this information under 703. I will constructively give a limiting instruction to the jury that they are not to consider this information for the truth of what it asserts, only for the effect it had on his investigation and the credibility and weight they should give to his investigation and to any conclusions that Mr. Renard made. And I was obviously caution defense and plaintiff not to use it for the truth of what it asserts in their closing argument.
Yes, Your Honor. Now, did you learn of any evidence suggesting that Karen Baja killed Lou Donaldson?
Excuse me. No, throughout the course of my investigation, I did not learn of any evidence that pointed to Miss Baja being involved with Mr. Donaldson's death.
Now, if you had evidence that Miss Baja did have something to do with Lou Donaldson's death, would your company have paid out the life insurance policy to her?
No. If we had evidence that Miss Baja was involved, we would not have paid out the life insurance policy.
So, Mr. Renard, at the end of your investigation, what was your final recommendation to your boss?
At the end of my investigation, after looking into the surrounding circumstances, I determined that the will was legitimate, and because there was no evidence of any foul play or any involvement from Miss Baja in Mr. Donaldson's death, that everything seemed to be on the up and up, and that Summit Life Insurance should pay out the insurance claim.
No further questions, Your Honor.
Thank you, Ms. Patton. Mr. Trevisani, any cross?
Yes, Your Honor. May I proceed?
Sorry. Yes, you may.
Mr. Renard, can you see and hear me okay on your screen?
I can, yes.
I want to start by talking about something you mentioned on direct examination. Now, you remember you told the members of the jury, if we had evidence that Karen Baja killed her husband, we wouldn't have paid out. That's what you said, right?
That's correct.
So then I want to start by talking about the evidence that you did have. Now, you're aware that the defendant's husband disappeared on August 17th of 2012.
I am.
5 years later, you were asked to investigate the possibility if the defendant killed her husband, right?
That's correct, yes.
As part of that investigation, sir, you asked the sheriff's department for formal documents, evidence that they have pertaining to Lou Donaldson's disappearance.
That's correct.
But you know that the defendant's brother, Carl, well, he works for that sheriff's department, don't you?
That's correct.
that sheriff's department where the defendant's brother worked refused to turn over any of that evidence. Isn't that true?
They weren't releasing any evidence to the public because it was an active investigation.
Well, sir, I'm not asking for why you believe they didn't. I'm just asking what they did. And the sheriff's department, where the defendant's brother works, refused to give you those documents that you asked for, right?
Yes, but they told me that they weren't releasing it because it was still an active investigation.
But that's a yes to my question, sir. They never gave you those documents, right?
Correct. They weren't releasing anything.
You talked about an anonymous contact, but the truth is, sir, you never looked over a single police report as part of your work in this case, right?
I did not, no.
So let's talk now about what actually happened on August 17th of 2012. Now, as part of your work, you read the defendant's deposition, right?
That's correct.
You're aware that the defendant admits to being at home the night that her husband disappeared, right?
Correct.
The same home that she shared with her husband, right?
That's correct.
The defendant admits that she left her home at 3 a.m., right?
That is what she said, yes.
The defendant admits that she met up with her brother Carl at 3 a.m.
I believe that she left her home to get some food for some tiger cubs, and she asked her brother for assistance because her car broke down.
So it was even later than 3 a.m., sir, when she met up with her brother.
Yes, I believe so. Yes, that's correct.
You're aware that the defendant claims she was out getting milk that night, right?
Yes, for the tiger cubs.
And the brother that she met when she was out getting milk for those tiger cubs, you understand that to be the same brother who works for the sheriff's department in this case, right?
That's correct.
Now, you spoke to quite a few people as part of your investigation, right?
I did, yes.
You're an investigator, so naturally you spoke to Lou Donaldson's family, right?
Yes, that's correct.
You spoke to his friends.
No, I didn't speak to his friends.
You spoke to some business associates of Lou Donaldson, right?
No, that wasn't necessary.
It wasn't necessary to speak to any associates of the person whose disappearance you were investigating. Do I have that right, sir?
That's correct. They didn't seem like they were related to this claim or the allegation against Ms. Baja.
So, to clarify, sir, you actually haven't spoken to a single person that could tell you that they saw Lou Donaldson alive after the defendant met up with her brother at 3 a.m., right?
I'm sorry, could you ask your question again?
Yes, Mr. Renat. Now, you spoke to people as part of this investigation, right?
Yes.
You said you didn't think it was necessary to speak to some close associates of Lou Donaldson, right?
No.
So you didn't speak to anyone who's seen Lou Donaldson alive after that night on August 17th?
No, from what I understand, nobody saw him alive after that night, so there was no one to speak to.
Nobody saw Lou Donaldson alive based on everything you reviewed. Do I have that right, sir?
Based on what I reviewed, it seemed like he disappeared off the face of the earth.
Thank you, Mr. Renard. Your Honor, we have no further questions at this time.
Thank you, counsel. Ms. Patton, any redirect examination?
No redirect based off that, Your Honor.
All right. Mr. Renard, you are excused. The defense, you may call your next witness.
Yes, Your Honor. Before we proceed to our next witness, we would like to read in portions of the deposition of Carl Bannister.
Go ahead.
I'd like to direct opposing counsel's attention to the deposition of Carl Bannister, page 4, starting 3 questions from the bottom, question starting, were you involved?
And Mr. Janet, do you have the case problem one so I can scroll to it quickly?
I do not have, I have a paper copy, not an electronic copy.
I believe
Oh,
it's
no, I
page
have the
36.
electronic. Do you have the page number so I can just follow along?
I believe it's page 36, Your Honor.
Okay, thank you.
Thank you.
Just in case there's an objection, I'm following along. All right, you may proceed, Mr. Chancellor.
Question. Were you involved in the investigation of the disappearance of Lou Donaldson? Answer. No, it would not have been appropriate. I mean, I know the detectives and investigators who looked into it. I've been working with them for years and we were all pretty close, but I was not personally involved in the investigation. Question. Did you have a chance to view any evidence or look at the reports? Answer. No, I take my job seriously. I knew nothing of Lou's disappearance and I wanted to keep it that way. I was walled off from the investigation and that was fine by me. At this time, Your Honor, the defense calls Karen Baja to the stand.
And before we do that, Mr. Chancellor, was there any, I guess, deposition, cross-examination by the plaintiff of this witness?
No, Your Honor.
Okay, go ahead, Mr. Chancellor.
At this time, we call Karen Baja to the stand. Hello, Karen.
Hi, Mr. Chancellor.
Could you please introduce yourself to the members of the jury and spell your last name for the record?
My name is Karen Basia, Basia,
And where are you from, Karen?
from right here in Statesville, born and raised.
What do you do for a living?
I'm the owner of Wild Wildlife Tiger Emporium.
Could you tell the members of the jury a little more about exactly what Wild Wildlife is?
Sure. Wild Wildlife is a sanctuary and rehabilitation center for large cats, particularly tigers, and we work to rehabilitate them to a successful reintroduction into the wild.
Now, did you work at, I'm sure you're aware that working at a tiger emporium is not a common everyday job. How did you become introduced to such a unique profession?
More or less, it's been my passion for most of my adult life. I've been advocating for the protection of big cats for a very long time now.
Now, were you the only person who worked at Wild Wildlife?
No, I worked there with my husband, Lou. We were working there together.
Now, Karen, before we go any further, I want to talk about your husband, Lou. You know, you've been sitting here today, you've heard a lot, so I just want to clear a few things up. Karen, did you have anything to do with your husband's disappearance?
Absolutely not.
Do you have any idea whatsoever what happened to your husband?
I have no idea what happened to my Lou.
Did you break into Wild Wildlife?
Absolutely not.
Did you steal the lockbox containing the will?
Absolutely not.
Did you say, "I won" to Cam Donaldson?
Absolutely not.
Thank you, Karen. Now, I want to stay talking about Lou for a little bit. How long were the two of you married?
Well, I met my Lou in May of 2001. So by the time he disappeared in 2012, we had just celebrated 11 years together.
Now, is it true that Lou was married at the time you met?
Yes, he was. But when we met, he got a divorce pretty quickly thereafter. It was a love at first sight. It truly was a love at first sight.
Now, Karen, is it also true that Lou Donaldson asked you for a divorce?
Yes, he did. I did have some suspicions that he may have been seeing someone in Costa Rica. He would often take trips there. He would fly out there and really be gone at a moment's notice.
Now, Karen, upon hearing the news that Lou wanted a divorce, what did you do?
Well, I was very upset, but like all of our issues, like every marriage has problems. We worked, I knew we were going to work together to overcome this problem that we had.
Now, Karen, we've also heard a lot here today about August 17th into the morning of August 18th in 2012.
Yes.
can you tell the members of the jury what you were doing early in the morning, August 18th, 2012?
Well, that day, one of our mama cubs at the sanctuary had given birth to some beautiful new cubs. And those cubs get real ornery when they're trying to feed in the morning. So I figured it would be best if I go to our local supplier and pick up some food for those hungry cubs.
Now, I want to back up a step here. You said you were taking care of the cubs.
Yes, I was.
Was Lou at Wild Wildlife while you were taking care of the cubs?
I had not seen Lou since earlier that day.
And as you mentioned, you realized that you needed supplies. When you realized that you needed supplies, what did you do?
Well, just like any time, I hopped in my car and drove to the local grocer that gives us our food and went to buy food for those cubs.
And about what time did this trip to the store occur?
This was at about 3 a.m.
Now, Karen, with it being so late, why not just wait to go in the morning?
Well, I was already up, and I was just so excited about these cubs. That's probably one of my favorite parts about owning the sanctuary. So, and the cubs get very anxious if they don't have food in the morning. So I figured that was just get it done so I could put all my attention into feeding the cubs in the morning.
And Karen, were you able to get all the supplies you needed?
Yes, I was. There was no problem with that.
And after you picked up the supplies, what happened next?
Well, I went into my car to get back to the cubs, and my car wouldn't start.
Now, when your car broke down, what did you do?
Well, I reached for my cell phone and I realized I'd forgotten it. So just like in my old adventurous days, I waved someone down and used their cell phone to make a call.
And who did you call?
I called my brother, Deputy Sheriff Carl Bannister.
Why would you call your brother at 3 a.m.?
Well, I know Carl works nights and I knew he was working that day. So I figured he would probably be the best option for a ride.
And why not call your husband, Lou?
Again, I hadn't seen Lou since earlier in that day. And since he could just take off at a moment's notice like he had been, I just figured Carl would probably be the best option for a ride at that time.
Now, Karen, did your brother come and pick you up?
Yes, he did.
And was he able to get you home safely?
Yes, he was. There were no problems.
And when your brother dropped you off at Wild Wildlife, did he go inside?
No, he did not.
And what did you do?
Well, since it was so late, I got to bed pretty quickly so I could wake up in the morning and feed those cubs.
Now, Karen, did you ever see your husband, Lou, again after August 17th, 2012?
No, I did not.
And at that time, what was going through your head?
Well, you never want to assume the worst, and that's really what I tried to avoid. But, I thought maybe he had left to go to Costa Rica, but I wasn't sure what had happened to my husband. But as the days turned into weeks and into months and now into years, I had to make the most difficult decision of my life. And please go ahead.
And what was that decision, Karen?
I had to declare my Lou legally dead.
Now, when you had your husband, Lou, declared legally dead, what happened next?
Well, I inherited Lou's estate and I benefited from the life insurance policy that we took out together.
Karen, would you give all that money back for another moment with Lou?
I would give everything I have to be with my Lou again. Everything.
No further questions.
You, Mr. Chancellor. Mr. Ayers, your cross.
May I proceed?
Yes, you may.
Good evening.
Good evening.
Back in 2012, your husband wanted a divorce, right?
Correct.
But you didn't want a divorce.
And I would never want to divorce the love of my life.
So that's a yes to my question. You didn't want a divorce.
Correct.
Back in 2012, your husband was a rich man, right?
Correct.
His estate was worth about $5 million.
Correct.
He never got that divorce, did he?
Well, he disappeared, so we never got a chance to resolve that issue.
That's right. Your husband never got that divorce because on August 17th, 2012, he disappeared, right?
Correct.
And as a result of your husband's disappearance, you inherited the entirety of that $5 million estate.
Correct.
You also got an insurance payout.
Correct.
That was worth another $5 million, right?
That's the way my Lou wanted it.
Let's talk about what you say happened on the weekend he disappeared. Now, on direct examination, you said that late at night on August 17th, early morning on the 18th, you left the house, right?
Correct.
You left to go buy milk
Yes.
at 3 a.m.
Yes.
But you can't show us any receipts from that milk purchase.
Well, we just have an account there, so I just didn't think I didn't want to carry one around with me.
I didn't ask anything about an account or what you wanted to carry around. I'm asking if you can show us a receipt from the purchase you said you made at 3 a.m.
I do not have a receipt for that purchase. It was a long time ago.
Now, you also said that you left your phone behind at home, didn't you?
Correct.
That means you can't show us any GPS data that shows you actually went to the shop.
I can't.
And then your car broke down?
Correct.
You can't show us the receipt from a tow company.
I cannot.
Can't show us the receipt from a repair shop.
Correct.
So you borrowed a stranger's phone, right?
Correct.
That person whose phone you borrowed, they're not on your witness list today, are they?
They are not.
But regardless, you managed to make a phone call.
Yes.
But you didn't call your husband, did you?
Well, I wasn't sure if he was home.
Oh, that's
I
right.
didn't.
You said one of the reasons you didn't call your husband is because you weren't sure he was at home?
Yes.
But you just come from your home, right?
Well, I hadn't seen him, and it wasn't unusual for him to take off in a moment's notice, like I said.
I'm not asking anything about what was usual for him or whether you'd seen him. I'm asking if you'd just come from your home.
Yes.
And yet you didn't know if your husband was there.
Correct.
So instead you called your brother.
Yes.
Your brother who works for the sheriff's department.
Yes.
And after you met up with your brother at 3 a.m., you never saw or heard from your husband again, right?
Correct.
After you met up with your brother at 3 a.m., to your knowledge, no one ever saw or heard from your husband again.
Correct.
Now, there's something I want to get straight. You said on direct examination that when you got back, you went to bed.
Correct.
But that's not true, is it?
It's not.
Didn't you go to the office?
No.
It's your testimony that the night that your husband disappeared, you did not go to the office.
I'm come to think, I may have stopped by the office.
Well, let's clarify it. Have you got a copy of your deposition in front of you?
Yes, I do.
You remember being deposed, right?
Yes.
You had to take an oath.
Yes.
The same oath you took today.
Yes.
An oath to tell the truth.
Correct.
So if I can direct court and counsel's attention to the second page of that deposition, Mr. Trevisani, Your Honor, may Mr. Trevisani display it on screen?
Yes, and you can, if you tell me the page number, I can go there as well, counsel.
Yes, Your Honor. I believe it's page 44 of the PDF.
Thank you.
Looking at the is this a copy of your deposition, Mr. Beja?
Yes,
It seems to be accurate, right?
yes,
Now, looking at the sixth answer on that page, you specifically said, "That is why I went to the office the night my Lou went missing." I read that correctly?
yes. I stopped by the office, but it was just briefly. I didn't, it wasn't anything out of the ordinary. I have a right to be at Wildlife.
I didn't ask anything about the context for you going to the office. I just asked if I read that correctly. And I did, right?
You did.
Okay. Let's talk about your husband's disappearance. Matt, you said on direct examination that your husband would sometimes fly off without telling you, right?
Yes,
But when you got home that night, August 18th, 4 in the morning, your husband's suitcases weren't missing.
not to my knowledge.
His clothes weren't missing.
Not to my knowledge.
His toothbrush wasn't missing.
Again, not to my knowledge.
You said your husband would sometimes fly off without telling you, but he always came back, right?
Correct.
You said that you loved your husband, right?
Absolutely.
You said you prayed for his return.
Absolutely.
You called him the love of your life.
Correct.
But when you got home and found that he disappeared, you didn't call him.
Correct.
You didn't text him.
Correct.
You didn't email him.
I did not.
For the last 8 years, your husband's been missing, right?
Correct.
But you've never hired a private investigator to go find the love of your life.
Correct.
In the last 8 years, you've never once even tried to contact Lou Donaldson.
Correct.
No further questions.
Thank you, Mr. Ayers. Mr. Chancellor, any redirect examination?
Yes, Your Honor, briefly. Now, Karen, I just want to make something very, very clear. Some dates and times seem to have been confused on cross-examination. On the night, or let's rephrase, the early morning of August 18th, 2020, after your brother picked you up, where did you go?
I went home so I could wake up in the morning and feed the cubs.
Now, on the morning of August 19th, 2020, when the alarm went off, you went to the office, correct?
Yes.
Objection leading?
It was leading, but we got the answer, and I will overrule for this purpose. But Ms. Chancellor, please try to keep the rest of the redirect examination open-ended questions.
No further questions, Your Honor.
All right. This witness is excused.
Thank you.
And defense, any further witnesses or evidence that you want to present?
No, Your Honor, at this time, the defense rests.
At the defense rests. If I can have the timekeepers calculate the time left for each side. And while they are doing that, I will turn to the plaintiff. Is there any motions the plaintiff wishes to make prior to closing arguments?
No, Your Honor. We just request a brief recess before closing.
And from the defense, any motions that you would like to raise at this time?
Yes, Your Honor, we would re-raise the same motion that we made after the close of the plaintiff's case in chief for the reasons we raised it.
I will assume that the plaintiff would respond the same way, and I will deny that motion. We will take a very brief recess before closing arguments. I have it at 7:55. We will take a break to 8 o'clock, and we will begin closing arguments then, and we will get a time check from our timekeepers right before we start. So I'll see everyone in 5 minutes. All right. one more. There we go. All right. If everyone can see from the chats, we do have the time check. Plaintiff has 30 minutes, defense has 34 minutes. And with that, we will proceed to closing arguments. Plaintiff, whenever you're ready.
Thank you. May I proceed?
Yes, you may.
May it please the court. It's a quiet Sunday morning until the alarm goes off. The defendant has just broken into their husband's office and stolen the lockbox containing their most important financial documents. It's only been 36 hours since Lou Donaldson disappeared. The police don't know he's missing. His daughter doesn't know he's missing. But not only does the defendant know he's missing, they know he's never coming back. When Lou Donaldson threatened divorce, the defendant made him disappear. Now today, we have the burden of proof. But our burden wasn't the one you usually think about when one person is accused of killing another. We didn't have to prove our case beyond a reasonable doubt. Our burden was a preponderance of the evidence, more likely than not. We had to prove that it was more likely than not that the actions of the defendant led to Lou Donaldson's death. And I want to be very clear about that, because we heard evidence today about multiple wills, handwriting analysis, forgery, fraud. Members of the jury, this is not a case about forgery. This is not a probate case. This is not a case about a forged will. We agree that the will that grants the defendant $10 million is legitimate. I want to be very clear that we've presented evidence today that the defendant killed their husband. And the defense has presented evidence that the defendant might not have also forged it. So let's talk about the evidence of a murder, because we have proven our case today using 3 simple facts. Lou Donaldson told the defendant he wanted a divorce. 2 weeks later, he was dead. And the defendant is the one who killed him. So let's take those one at a time. Fact number 1. Lou Donaldson told the defendant he was going to divorce them. Not maybe, not possibly. He told the defendant, I am going to file for divorce. Well, that put the defendant's life of luxury in jeopardy. You see, Lou Donaldson was a rich man. A successful car dealership, private planes, exotic animals. The defendant told you today, those animals were a passion. They spent their life caring for those animals. They told you today, they didn't want a divorce. So when Lou Donaldson told the defendant that he was ready to file, the defendant threatened to kill him. That brings us to fact number 2. 2 weeks later, Lou Donaldson was dead. Now here, I want you to remember the testimony of Taylor Pry. Ms. Pry told you that when the defendant was initially questioned about Lou Donaldson's disappearance, well, the defendant came up with an amazing theory about how they'd flown to Costa Rica and gone off to live with their mistress. In fact, Their own expert witness today, Dr. Renard, told you today, I have no idea where Lou Donaldson went. It's like he just disappeared off the face of the earth. Members of the jury, these theories are nonsense. If Lou Donaldson had decided to just move to Costa Rica, go off and live with his mistress, why isn't there a single penny missing from his bank account? Why isn't there a single transaction showing him alive after August 17th? If Lou Donaldson had decided to move to Costa Rica, why weren't his suitcases missing? Why weren't his clothes missing? Why wasn't anything missing? Except the man himself. If Lou Donaldson had decided to move to Costa Rica, why? Why would he leave the defendant all of his money? Now, I know that the defendant told you today that, their marriage had some problems, but at the end of the day, they were working through it. Members of the jury, this was not just a marriage with some problems. You heard that the defendant threatened to kill Lou Donaldson. Lou Donaldson asked for a divorce. Lou Donaldson was ready for a divorce. But somehow, the defense wants you to believe that Lou Donaldson just decided to leave and, well, the defendant could have everything. Most importantly, members of the jury, if Lou Donaldson had decided to move, get out of the country, why wouldn't he tell his daughter? By all accounts, they had a loving relationship. They were close. They'd worked together for decades. Why would he let his final words to his daughter be, I'll see you on Monday? Because Lou Donaldson isn't in Costa Rica. Lou Donaldson's dead. That brings us to fact number 3. The defendant is the one who killed him. Now here is where it's so important that you understand our vote. Because we don't have to prove how the defendant killed their husband, what exact weapon they used, or what they did with the body. No. We just have to prove that they killed their husband. And we have proven today that more likely than not, they did. The defense, in their opening statement, they told you that at the end of this trial, you'll be left with questions, things unseen, unknown, and unanswered. And to the jury, we haven't left you with anything unseen, unknown, or unanswered. We've shown you what's happened. What's unseen is Lou Donaldson, after the defendant met up with their brother at 3 a.m. What's unknown is what evidence the sheriff's department collected. Same sheriff's department where the defendant's brother works. And what's unanswered is the defense's idea of what actually happened in this case. They've told you nothing. All they've told you is that on August 17th, 2012, well, the defendant was looking after some tiger cubs. And then they ran out of milk. So they had to go and buy some. Of course, couldn't show you the receipts from that purchase. But they'd left their phone at home, so they couldn't show you the GPS data, showing they actually went to buy anything. Their car broke down, but they couldn't prove that to you. And then they borrowed the phone of a stranger who you didn't hear from. And then we don't know what's happened. Because today on the stand, the defendant told you, well, I got home, my husband was missing, and then I went to sleep. But when the defendant was deposed, they told you, well, I came home and my husband was missing, so I went to the office. They can't get their story straight. The only thing that we know for certain happened that night. We know the defendant met up with their brother. We know the defendant went home with their brother. We know they arrived home after 3 a.m. And we know that Lou Donaldson was never seen again. Members of the jury, we have met our burden of proof. I want to show you the jury verdict form. On behalf of Lou Donaldson's estate, we're going to ask that you return the $10 million that the defendant gained as a result of killing their husband. And on behalf of Cam Donaldson, we ask that you award whatever a loving father is worth to his loving daughter. You heard today from the defendant. You heard that on August 17th, their husband disappeared. You heard that they loved their husband. But their actions speak louder than their words. Because when they discovered that their husband was gone, they didn't call, they didn't text, they didn't email, not the night their husband disappeared, not the next day, not for the next 8 years. On August 17th, 2012, Lou Donaldson said goodnight to his daughter. But he never got to say goodbye. Because he didn't know then what you know now. That waiting for him at home with a plan was the defendant. We ask you to find the defendant liable for the death of Lou Donaldson. Because when he threatened divorce, the defendant made him disappear. Thank you.
Mr. Ayers? Mr. Chancellor, your closing argument whenever you're ready.
Just going to wait for opposing counsel to turn the camera on. Thank you. Unseen, unknown, unanswered. Members of the jury, we are here today based on nothing more than a false and manipulated narrative that blames Karen for the death of Lou Donaldson. Let me be very clear. Karen Baja did not kill Lou Donaldson. In a few moments, the judge is going to instruct you on the law that you are to apply to the facts of this case. And as you heard from the plaintiff, it is their burden to prove each and every element of the claim brought forth against Karen. Which means if they fail to prove just one, they have failed to meet that burden, and you cannot find Karen liable. So I want to focus on what they cannot prove to you. In order to succeed here today, the plaintiff had to prove that Karen Baja's intentional or reckless conduct caused the death of Lou Donaldson. And I want you to think about that. I want you to think about all of the evidence that was presented here today. I want you to think about all the testimony that you heard. I want you to think about how no one saw what happened, how no one knows what happened, And a blanket statement that we have proven Karen killed Lou is not proof that Karen killed Lou. Not a single person in this courtroom can tell you for certain what happened to Lou Donaldson because nobody knows. The plaintiff has failed today to even distinguish whether the act was intentional, whether the act was reckless, whether it was both. And you know why? Because they never identified it. They stood up there before you and they said, Karen killed Lou. And they said, we left you with unanswered questions, as if we have a burden at all in this case. Members of the jury, the burden rests solely with the plaintiff. We did not have to call a single witness. We did not have to bring forth any evidence. So do not for a second let the plaintiff make you believe that we had to prove something to you. It was their burden to answer those questions, and they have absolutely failed that burden. As I mentioned, a blanket statement that Lou wanted a divorce and Karen killed him. Let's talk about these questions. When exactly did Karen kill him? How exactly did Karen kill him? Where did this supposedly take place? Did you, members of the jury, hear any of that from the plaintiff here today? The answer to that is no. Because the plaintiff has failed to prove that Karen had anything to do with Lou's disappearance, let alone his death. And over the course of this trial, they have failed to produce a single shred of concrete evidence to convince you otherwise. They don't have Lou Donaldson's body. There's no autopsy. There's no cause of death. There is no DNA. There is no blood. There is no eyewitness to what actually occurred. There is no fingerprint. They don't have video surveillance, photographs, nothing to support that claim. For those reasons alone, members of the jury, the plaintiff has already failed to meet their burden, and you cannot find Karen Baja liable. But they don't stop there, and they continue to put together this false narrative. Now, Mrs. Pride took the stand today and talked to you a little bit about her investigation. Now, she stood before you and said that the Pioneer Sheriff's Department didn't do a thorough investigation because they couldn't produce any evidence and they never found a body. And in her next breath, confirmed that she can't produce any evidence, nor did she find a body. But for Ms. Pride to get on stand today and find somehow, some way, Karen is responsible for the death, again, without specifics, shouldn't surprise you, because it is exactly what she was hired by Cam Donaldson to do. Unanswered questions. Chris Renner took the stand here today, and he told you that insurance payouts in a life insurance policy only go to the person as the sole beneficiary if there's no evidence of wrongdoing. And that life insurance policy was paid out. Now, the plaintiff came before you today and spoke to Karen Baja. And in that conversation with Karen Baja, they attempted to manipulate the timeline as the facts actually occurred in order to fit the narrative that they are trying to convince you of. And members of the jury, I called them out on it. There is no body. There is no DNA. There's no fingerprints. There's no blood splatter, nothing. But the plaintiff stands up here, and instead of actually proving the elements that they had to prove in today's case, instead of actually proving that Karen Baggio was responsible for the death of Lou Donaldson, they convinced you that Lou filed for a divorce, which he did, that Lou is dead, which no one can actually confirm, and that Karen did it. Karen did it. At no point in time did they produce any evidence as to how she supposedly did it. At no point in time over the course of this trial did they say what intentional act caused the death. At no point in the course of this trial did they say what reckless act caused the death of Lou Donaldson. To come before you and claim that the defense has left too many questions unanswered, they have answered nothing. Because what happened to Lou Donaldson was unseen. It is unknown. It is unanswered. And it is unproven. The plaintiff came before you today and attempted to weave together something out of nothing. They came before you today and gave you just vague enough details in an attempt to convince you of a false narrative, to distract you from the fact that they don't have any actual evidence to support it. And members of the jury, as you are deliberating today, it is important to focus on the evidence and testimony that was presented. But remember everything the plaintiff failed to present. All the questions they could not answer. And when they come before you and tug on your heartstrings and make the emotional pitch, members of the jury, separate the facts from your emotion. Because when you do, there is only one verdict that the facts support. Find Karen Baggio not liable.
Thank you, Mr. Chancellor. Is there any rebuttal closing by the plaintiff?
Yes, Your Honor. May it please the court.
Yes.
When Lou Donaldson threatened divorce, the defendant made him disappear. Now, opposing counsel has just stood before you and told you that we presented no evidence today. But when you go back to deliberate, you'll read the jury instructions and you'll read that circumstantial evidence is just as meaningful, just as valid as direct evidence. We didn't have to show you blood or an eyewitness. We had to show you evidence that the defendant killed Lou Donaldson. You heard the defendant on the stand today. Whether it was the 18th or the 19th, they didn't seem too sure, but they were very clear. They went to the office the weekend that their husband disappeared. Members of the jury, you heard undisputed evidence that the defendant went to their husband's office right after Lou Donaldson disappeared and took a lockbox containing important financial documents. And in doing so, they leave a key question unanswered. A question that we have answered. Because if they went to go get that lockbox when Lou Donaldson was alive, what were they planning to do with it? And if they went to go get that lockbox knowing Lou Donaldson was dead. Well, how could they know? That, members of the jury, is evidence. Not just that Lou Donaldson is dead, but that the defendant is the one who killed him. Find the defendant liable. Thank you.
Thank you, Mr. Hires. If I can get all of the advocates on the screen, we will submit this case to the jury. As I'm sure you all know from the prior 2 rounds, we're not giving comments through the video. We're gonna go submit our scores online. We will all type our comments in that you guys will get later. I just wanna say, as you guys sign off for the night, extremely good job to all advocates. I'm sure you've heard this from other judges, because it is true. It's fantastic job. It was truly fun to judge this. It was truly fun to watch the advocacy from all 4 of you guys. Just fantastic job. With that, I'm sure wherever you are, it's late. So I'll let you get some rest for tomorrow morning's round. Thank you, everyone.
Thank you.
Thank you.